Watching News at Prime, let's get into this conversation now. Teaching at Tiyelelani Secondary School in Soshangu has been disrupted for a third day. The Gauteng Education Department has suspended the principal and 3 teachers pending an investigation into sexual assault allegations. It's claimed that some pupils were assaulted by a teacher, while a bus driver is accused of having an inappropriate relationship with a learner. Now, the principal allegedly failed to act when the allegations first surfaced. Pupils staged fresh protests today, moving between schools. The department will meet with parents this weekend. Well, let's discuss this some more, particularly the act of sexual misconduct. These are cases against teachers, and that's why we're joined tonight by the South African Council for Educators. The CEO is Mokgalane, who talks to us from Centurion. Ms. Mokgalane, good evening to you. Thank you very much for your time. Firstly, are you familiar with the incident that is alleged to have taken place at Tiyelelani Secondary School in Soshangu?
Good evening, Koli. Yes, we received the report through the media, obviously, and through social media. When we see those kind of cases, as council, we have a duty to make sure that we deal with the case. And therefore, our team will be going to the school tomorrow to deal with the investigation first before we can even say whether there's a case to answer or not.
All right. What is SACE's role? I know that you are familiar with the case and you are now getting involved. When you do get involved in such cases, how far do you go as far as teacher conduct is concerned?
We have a procedure document, which we call the Disciplinary Procedure and Processes. We will definitely go to the school after we have sent the letters to both the victims and also the school, as well as the perpetrators. And obviously, there's an OD letter that we sent so that both parties can be in a position to understand issues that they need to respond to.
Just going through...
Once that is...
I apologize. Sorry, I thought you had finished your thought. Please continue.
Once that is done, we will then send our investigation team to go and obviously, there's a need to check if there's a case to answer. And the prima facie evidence will be used to say whether we go for disciplinary hearing or there are other processes that we need to deal with. So if there's a case to answer, the second step would be to deal with the disciplinary process where there will be prosecutors, there will be presiding officers, there will be the children. However, the children need to be accompanied, especially because most of our children that are being violated are minors. And therefore, intermediaries also have to be there so that they can be in a position to protect the children. The hearing will be conducted. If there is a guilty version, then it means there must be a sanction that we mete you out. And let me just take you through our sanctions. It will be either, depending on the nature of the case and the merits, it will be either you are struck off for a particular period and also for a fine that is equivalent to your 1-month salary. But the harshest one would be when you are struck off indefinitely from the role of educators. That particular struck off will go together with other processes that are linked to the sanction. One would be because you've been struck off from the role, and SACE is the one that gave you the license to practice, your employer, which is your Provincial Education Department of Education in this case, doesn't have a choice, but in terms of the Employment of Educators Act, you are deemed to have resigned. Obviously, you will leave the system. But secondly, because you've dealt with a minor in terms of the sexual abuse, sexual assault, it means the Department of Social Development must come in where we report for your name to be included in the Children's Act. And obviously, you would know that when you are in Children's Act, you are included in Children's Act, you would not be fit to practice, you would not be suitable to work with any child. And I always make it even an exaggeration. It's not an exaggeration, but to make a case to say you are not even fit to be a mother or a father of the child in your own house.
Yeah.
Remember, Children's Act is applicable throughout in fact, your household, your church, your school, everywhere.
Yes.
But the last area that I think the sector is not doing well with is reporting to SAPS. Because for one to be included in the Department of Justice and Constitutional Development's National Register of Sexual Offences, it means that person must be reported to the SAPS first. And the SAPS has got to deal with the process and convict you so that you can be included in the register for sexual offenders. However, if you're not convicted through beyond reasonable doubt, to go through the processes of beyond reasonable doubt, you won't be included in that particular register. So this is the broader process that we go through. But we understand that along the way, the secondary trauma that the children are suffering. In some instances, parents would say, my child can't go to SACE for the first time and then go to SAPS to really prove the case beyond reasonable doubt. So those are some of the challenges that we might have.
Okay. I think you've painted a very broad picture indeed. Let's go back to what you said initially, that if there is a case to answer, then disciplinary processes will ensue. But for you to get there, you obviously need to get statements from the learners that were allegedly abused. And I've gone through what the reporting around this incident has been, and that is that there is fear among some children to speak out, to say, teacher X did this, teacher Y did that. Who handles the children, and how private and comfortable is that space for them to be able to speak freely about what exactly happened?
That is where the collaborative process it comes in terms of us working with other stakeholders and also other government departments. You remember that your Department of Justice and Constitutional Development is responsible for the courts, and therefore there are children's courts which are suitable for children to be able to talk freely without them being intimidated or without them having fear. But I've mentioned earlier on to say, even with that, they need to work with intermediaries because they are minors. They need to be assisted in terms of the evidence that they are presenting before the tribunal. Sometimes they are being, that is why the importance of the children's court or any other means that will be used so that the children cannot be in a position to see the perpetrator. Otherwise, it becomes a problem because they have a tendency to find a way of intimidating the children.
Yes.
Because they are young, and when they see the teacher, they might be frustrated and not say what they're supposed to say.
And that's exactly why we're talking about a safe space for them to speak out. You then mention the failure to report these cases to the police. We know with this case now, with this story, that the school principal was placed on suspension unless that has been lifted. I'm not aware if that indeed is the case. Whose responsibility was it to report this matter to the police? Is it the parents of the children, or does it start with the school principal?
Actually, it starts with the principal. Because remember, the principal is the accounting officer at the school. Everything that happens within the school, you're supposed to be knowing what's happening, or the cases have been reported, and therefore the principal has got a duty. In fact, the Criminal Law Sexual Related Matters Act is very clear that you must report as the principal, as the educator. In fact, for the first time when it was amended last year, or year before last, it's mentioning the educator, and principals by profession, they are teachers before they are principals, and therefore they have a responsibility to report. Now, what we've done as says in terms of our sanctioning policy and our procedures is that when we find out that the principal failed to report. We charge them because they are as guilty as the person who sexually assaulted the child because they failed to report. And some of them would hide the whole thing under the carpet because of trying to really secure the name of the school or to get favors from the perpetrator. So that's why we feel it's very important for them to report.
And so,
parents, yes, from Children's Act, parents have to report as well.
yes. So the principal of this school, it's safe to say, therefore, right now that he will effectively be charged by yourselves as SACE because of the failure to act on this matter when it was initially reported to him.
Yes, if our investigation can prove that indeed he failed to report, then clearly, definitely, we're going to deal with that. But also, you'd remember that your Children's Act and Criminal Law Sexual Offences Matters is saying, should you have knowledge, it doesn't say proof, should you have knowledge that the child has been violated, especially sexually and otherwise, you have a duty to report to the authorities, to SAPS, to any other authority that can be able to deal with the matter.
All right. Under what conditions would a perpetrator be given a fine of a month's salary? Because someone listening is saying, if this person has gotten to a stage where they are now being fined, it means that they are guilty of this act. Now, the worry here is that, as you've said, they're dealing with children, they're dealing with minors, and if it is a case of sexual assault, surely they cannot go back and practice as a teacher.
In most cases, it will be sexual-related misconduct cases where there was proposal only, and there was no further action in terms of either penetrating the child or even sexual assault. Remember, sexual assault is taking it by force. It's when they find a moment, especially where they've got offices, where they've got space, finding a moment to grab the child, and a minute will be enough for them to really sexually assault that child. So where there is just a proposing of love relationship, that's where those kind of sanctions of saying you are struck off, however the struck off is suspended for a particular period, it comes with a fine.
And I take it, therefore, that you are striking them off for a period because you're hoping that they're going to change behavior. Oftentimes, we see such people reoffending. Is that not dangerous? If a person is accused of such, as you say, they were found to have only merely proposed, but it didn't go further. It means that they might try their luck next time. Is it not safe to just remove them altogether?
It's a difficult one, Goli, because we've got different types of sexual misconduct cases. This is the lowest one that is not coming closer to coming to further action. That is why we are saying within this period, should you continue to go further or propose again, then we'll take a different measure. So that's the only way that how I can respond to it, because remember, we're dealing with procedures, we're dealing with fairness, we're dealing with justice, and also all those kind of issues that we are required to make sure that in dealing with the process, we are careful in terms of not being litigated unnecessarily. As you would have seen, there have been cases, 1 or 2 on corporal punishment that we've been litigated on some of our procedures that we needed to tighten up.
Thank you very much for the explanation and the processes involved here. CEO of the South African Council for Educators, Ella Mokgalane.